Welcome to Miranda Warnings Roundtable, discussing legal issues and current events. This week on Miranda Warnings Roundtable, we discuss Governor Kathy Hochul's nominee to be Chief Judge of New York's Court of Appeals, the Honorable Hector LaSalle, currently the presiding judge of New York's Appellate Division's Second Department. Under New York state law, Governor Hochul must select from a list of 7 candidates determined by a bipartisan New York State Commission on Judicial Nomination. The governor's selected candidate must be considered for confirmation by the New York State Senate within 30 days of the nomination. Presiding Judge LaSalle was one of the 7 candidates recommended by the commission. The New York State Bar Association, through its Committee on Judicial Nominations, investigated, interviewed, and rated all 7 of the candidates and found each of them qualified to be Chief Judge of the New York State Court of Appeals. Presiding Judge LaSalle was one of 3 found by the New York State Bar Association to be well qualified for the position. The New York State Bar Association's highest possible rating. Former Chief Judge of the New York Court of Appeals, Jonathan Lippman, in a recent Times Union article, commended the selection of Presiding Judge LaSalle, calling him extraordinarily qualified. A group of 46 law professors have written a letter to Governor Hochul expressing concern over Presiding Judge LaSalle's decisions. The group focuses on 3 decisions out of thousands that Judge LaSalle either wrote or participated in his career. Although the New York State Bar Association found Presiding Judge LaSalle to be well qualified to be Chief Judge of New York's Court of Appeals, we are a nonpartisan organization and do not take sides in the political battle taking place in the Senate over Judge LaSalle's nomination. However, the Court of Appeals and selection of its Chief Judge is of the utmost importance to the New York State Bar Association, its members, and to the legal community. We're joined at the round table by Vin Bonventre, the Robert Jackson Distinguished Professor of Law at Albany Law School and author of NewYorkCourtWatcher.com, where Professor Bonventre has written a 3-part series on Chief Judge Designee LaSalle's nomination. And we're also joined by Liz Benjamin of Marathon Strategies.
Just to be clear, I haven't written anything.
You're already heckling.
I'm heckling, yep. Mm-hmm.
Former of Marathon Strategies, yes. Former host of Capital Tonight, steeped in Albany politics for decades, and a heckler, known heckler.
If I'm a known heckler, Vin is a known liberal.
She doesn't write, but she sure talks a lot.
Oh, it's already.
And we're very grateful to have both of you on to talk about this very important nomination. This nomination has become a political battle, as you know, in the New York State Senate. And I should point out that the comments of Vin, Liz, and myself, for that matter, although often educational and insightful, are not the policy or position of the New York State Bar Association. So let's get to it. I'd like to start on a positive note with what Governor Hochul said about her choice. She said New York's Court of Appeals has a long history as a beacon of justice, and Judge LaSalle is an outstanding jurist in that tradition. He has the skills, experience, and intellect to ensure that our highest court is seen as a leader across the country. Judge LaSalle has a sterling reputation as a consensus builder, and I know he can unite the court in service of justice.
I don't think he can unite the court.
Well, let's talk about that. Isn't an experienced, respected, and moderate judge exactly what the Court of Appeals needs right now?
Well, before the commission even came out with its list, I had been hearing from quite a few individuals, prominent individuals, and liberal Democrats that Hector LaSalle was terrific, that they hoped that he would be put on the list. Mm-hmm. So I don't know the man either professionally or socially, but what I had heard from those who do know him, who've worked with him, who have argued before him, he comes very, very highly recommended.
So the former Chief Judge Jonathan Lippman was quoted in the past 24 hours in a variety of locations saying that actually Hector LaSalle is exactly what the court needs right now, as particularly since it's trying to recover and get back still underway to its operations in the post-COVID era after the court system was largely shut down. And needs to really, from an operational standpoint, recover from that and perhaps modernize, which I know is sort of an outside chance when it comes to the court system. But still, his administrative capability, I think, is something that people feel very strongly about. And the historic nature of his appointment is significant. I mean, let's just be clear, right? I mean, he would be historic as the first Latino to hold the position. And that's significant. However, Vin, when you say that you had heard signals regarding Hector LaSalle, we also heard not signals, very clear clarion calls from a number of elected officials and advocates on the progressive side of the aisle saying that they were unhappy with the direction of the court under Janet DeFiore and they wanted a change and they wanted somebody significantly left. So this is not a surprise what we find ourselves at this moment, right?
Right. And I would agree with them on that. I think the Court of Appeals over the last several years has lost a great deal of prestige. It has not been the great state high court that it has been historically, traditionally. That's absolutely true. And would I prefer, just like them, a more liberal chief judge to turn the court around so that it becomes, again, a bold, progressive court like it was under Jonathan Lippman? Absolutely. But that does not mean that Hector LaSalle is not a fine choice. And that doesn't mean that his record ought to be mischaracterized by those who would prefer somebody more liberal.
I think let's just also note that before we even delve into the meat of this debate, and it's very nuanced. I mean, there's a lot of people who are weighing in, and then there's a lot of politics at play with the Democrats making an interesting attempt yesterday to stack the Judiciary Committee in the Senate. So Hector LaSalle never even makes it past there because they're worried that the Republicans will cross the aisle and give the votes to him that is necessary to get him confirmed, which was a pretty blatant move in terms of legal, but still blatant in terms of, one might argue, manipulating democracy. But the interesting thing that we find ourselves here, because really, one might argue, the politicization of the Supreme Court has set the stage for, I think, lower courts to be scrutinized with a more intense light.
Yeah, so, there's nothing wrong with scrutinizing a judge's record that is going before to go to the Court of Appeals, and presiding Judge LaSalle has a substantial judicial opinion record to look at. I think one of the concerns is that this group of law professors, and I assume, Vin, that you're not one of them.
I did not sign that letter.
No. Cherry-picked a couple of decisions that, first of all, Judge LaSalle didn't even write. He signed on to, so, he supports it, but he didn't write those decisions. And secondly, and this is what I'd like to talk about, they don't really stand for the propositions that those law professors say that they do. And I know, Vin, that you've written a nice piece that came out yesterday that goes into a little detail. And I think in this particular instance, we're going to need to get down into the weeds because those decisions, I don't think, have been fully and fairly represented by those that are opposed to Judge LaSalle.
You come to a point, I mean, it's very interesting in terms of the ability to manipulate decisions by the court for political purposes. For example, and this is not an instance in which Judge LaSalle was involved, but let's say hypothetically, you had a case before you in which you had an individual who clearly was seeking to perpetrate a fraud by a false slip and fall in a Walmart. And if you found against the individual in favor of the Walmart, are you therefore pro-corporate America? or are you anti-fraud? So I think that to determine an individual's ideology based on a few, as David noted, cherry-picked cases in which he didn't write the decision, but I think it's fair to say that if you put your name to something, then you agree to it as a judge.
Fair.
So let's put that aside. Let's assume that he agreed or he would have been in the dissent. But the point is to say, well, based on X, Y, Z cherry-picked cases, he therefore is anti-abortion or anti-union or anti-what have you is not necessarily fair.
You're surprisingly making a very good point.
Thank you, Din. Thank you. Thank you. It happens once a year, at least.
Maybe because she read your article.
I didn't actually.
That could be it.
I didn't on purpose read the article because I didn't want to be clouded or swayed in any way before I came in.
You mean swayed in the opposite direction?
I don't have any particular standing on this, other than I think that the process has definitely been called into question.
Right, but it's certainly, I think, a healthy development that some people or more people are actually looking into the record of whoever it is that's going to be placed on the Court of Appeals. I mean, come on, usually it's a joke.
That's true.
Usually it's a joke. And most law professors have no clue about what goes on at the New York Court of Appeals or the New York judiciary, because they're so obsessed with the federal system and the United States Supreme Court. So it is a healthy development that somebody is taking an interest in it. I do salute that. On the other hand, when these groups, whether it's particular progressive professors or organizations, when they look at a judge's record, I mean, come on, you should be honest and you should be fair about it. And I just don't think they have been fair at all with regard to Judge LaSalle's record. Now, is he a liberal? No, it doesn't seem as though he's particularly liberal. Is he somebody that I think would be the great, like I thought Jonathan Lippman was great? No, it's so far in his record, his record doesn't suggest that. But by all accounts, serious accounts, is he a fine jurist? Absolutely.
So out of the cases in question that the opponents have cited as problematic, it seems to me that the area where they have the strongest leg to stand on, to the degree that they have a leg to stand on, is the union, is the labor argument. All
right, well, let's talk about that, because I think that there's they've said that he's anti-union because of the case of Cablevision systems
case
versus communications workers, right? And I'm going to give the site 131 AD 3rd, 1082, because you should read it and see what it's about, right? It's a defamation case. They brought a defamation case against the union, against the union leaders, and against the union leaders in their personal individual capacity. The case was dismissed against the union and the union leaders as union leaders.
Yes.
But Judge LaSalle, the decision that Judge LaSalle signed on to, said that if they could prove that the union leaders were acting in their individual capacity, the case could go forward. Not that he was ruling against them in their individual capacity, just that the individuals would have the right to bring a lawsuit against someone in their individual capacity. And as far as I can tell, that decision is in compliance with the law.
It's completely in compliance with the New York Court of Appeals precedent, the Martin v. Curran precedent, where that the union cannot be sued for defamation, union officials cannot be sued for defamation, but the Court of Appeals made it clear that libel claims, defamation claims can be brought against union members in their individual capacities. And that's exactly what the appellate division said in this particular case.
And let's also, just as an aside, libel has a very high bar, particularly for individuals who have public standing. So an individual who has a public position, like a union leader, and is well known within a certain sector. I mean, you're not talking about Leonardo DiCaprio in terms of stature and recognition in the public sphere, but it is very difficult to prove libel against someone. So
I think it's important to note that this was a motion to dismiss is a procedural motion right at the beginning of the case. This was a procedural motion. It talked about issues of law. It didn't get into the substance of the case at all. There's nothing in that decision that would indicate either pro or anti-union sentiments. Nothing in that case. Not in a procedural motion.
No.
I mean, the professor said that this shows hostility to labor and to workers. Oh, come on. That's not what it shows. I mean,
there was a dismissal of the case against the union. The case was dismissed.
Well, so then let's then subsequently go to the abortion case. That's a First Amendment case, if I'm not mistaken.
Yeah, well, let's, and I want to cite, I hate to interrupt, but I want to cite the case because the case should be read. It's Evergreen Association v. Schneiderman, 153, 83rd, 87. It was
Schneiderman, who was so pro-choice, just to be clear, like, again, let's remember what we're talking about here. There's a case. I mean, obviously, he was at the time the state's attorney, right? That's what you are as a state attorney general. And so subsequently, he is the one who's being named in this suit. But I mean, his dad was a leader and a significant supporter of Planned Parenthood. He was always super pro-choice. So again, let's just look at the context, because I think contextually, we're not considering the details. We are looking with broad brush strokes, as Vin just noted, hostility to unions. Like that's very arbitrary. I mean, just.
Yeah, and the Evergreen Association, which has been referred to as an abortion case, really doesn't have anything to do with a woman's right to choose or abortion rights. The Attorney General served a subpoena for documents on a pregnancy crisis center that was alleged to be illegally practicing medicine without a license, right? And the Pregnancy Crisis Center wasn't an abortion clinic. It was, in fact, quite the opposite. The concern was that they were dissuading women from having abortions potentially illegally practicing medicine without a license. The Attorney General sort of investigated this, had a subpoena for a broad spectrum of information, which the Second Department upheld the issuance of the subpoena for the information related to whether they were practicing medicine without a license. But
for most of that information, yes.
But for the other stuff like donors, donor lists, and that had nothing to do with the issue at hand, they said, well, no, you've gone too far. So there's, again, nothing in that decision that would indicate pro-life or anti-women's health, nothing in there.
And what did the law
about
professor say about that, Vin, specifically?
How is it that
they said it was shocking.
Hostile.
They said it was shocking, and that LaSalle does not understand the severity of the threat to women's rights.
But how? How?
Well, not only that, but to follow up on what David was saying, the United States Supreme Court has made it clear that with regard to information concerning membership in these nonprofit organizations, who the donors are, that smacks up against the First Amendment right of free association. The Supreme Court, in fact, just recently, maybe a year and a half ago, in the Americans for Prosperity case, ruled that California could not require not-for-profit organizations to disclose who their donors were, who their major donors were, because that would chill the right to association. So come on. I mean, I think that this decision was absolutely correct. And, I'm a liberal. I'm pro-choice. I just don't see this as an anti-pro-choice, anti-woman decision at all.
It doesn't substantively address anything with healthcare matters. I was thinking about, it would be akin to, let's say you had an abortion clinic and they were violating some sort of zoning law where they built an addition without getting proper zoning. And they violated the zoning law, and if a court were to hold, yes, you did in fact violate the zoning law, does that mean that the judge is anti-abortion or pro-life? It has nothing to do with it. And to cast this blanket over a judge is, I think, something that should be really, really looked into before you start saying things
So
like that.
again, I mean, we find ourselves back to the original point, which was, had we not been in a situation in post-Dobbs, then perhaps people would not feel as incited in terms of the need to, in their opinion, protect and create a progressive barrier at the state level. Now, let's just be clear.
Sure.
The right to access an abortion is in no way in threat in New York. I mean, in fact, the state has made it clear that it is welcoming individuals who are coming from other states and is willing to help them to secure abortion services if their own states have, not allowed that in the wake of Dobbs. So the idea that somehow we have to create some, progressive protection wall to prevent New Yorkers from being hurt by decisions that are made at the federal level is just false. But this is, and this is not really about, and I think that what we've exposed here just by sort of this surface discussion, I mean, it's not been all of that terribly difficult to find these cases and to just read them and to really figure out what they're about. This is about politics. This is not about jurisprudence. It's not.
Right, but Dobbs was an absolutely dreadful decision, but there is a silver lining to Dobbs, and that is, and you were just addressing this, Liz, and that is that maybe lawyers and judges will start actually paying attention to the state's
there was a decision in South
civil
Carolina.
rights and civil liberties protections.
But just South Carolina, the state in the last
South
48
Carolina,
hours.
that's
fine.
right, yeah.
So we are seeing already that at the state level, even in a state like South Carolina, which is not necessarily a bastion of progressive thought. I mean, that's a broad brush statement, but you know what I'm saying. It's not New York, not California. They just overturned the ban, the 6-week ban. Am I saying that right? They just overturned the ban. So there is an understanding at the state level across the nation, even in states and voters too. We saw subsequently overturning some of the more egregious in terms of preventing access to care for women who need it or want it, or under the advisement of their own medical professionals seek it. The purpose is we saw voters overturn it. So there are certainly backstops against Dobbs. This, though, is something entirely different. I see it, and again, I want to reiterate that I think it's important that what David said at the beginning. I am not speaking on behalf of NISBA. I am not speaking on behalf of anyone but myself. But I think that this is clearly an attempt by the progressives to curry favor with their base. That's what this is, about elected officials seeking to curry favor with their base in an increasingly left-leaning state. And a governor who is, also trying to strike a balance and was under fire during the campaign for not being progressive enough and also not being conservative enough when it comes to public safety. I mean, the woman is stuck between a rock and a hard place on any number of levels, but this is really just purely about politics, plain and simple.
And do the progressive politics really want to turn the New York Court of Appeals into something akin to the United States Supreme Court?
Well, clearly they do, or we wouldn't be having this conversation.
So, Democratic governors have to appoint somebody who's very left-wing, right? Ideologically very, very liberal. And then Republican governors have to appoint somebody to the Court of Appeals who is very, very ideologically conservative. And then we get this disaster that we have now at the United States Supreme Court. I think that would be terribly unfortunate.
Well, look, there's also another wrinkle to this, which is that you're talking about a court that made a decision that made the legislature very angry when it came to redistricting. And I do think that the legislature now, nobody said this to me specifically, and I don't think anyone would own up to it, but is trying to exact its pound of flesh in response to that particular decision.
I think there's some truth to that, and I think they were obviously upset with the court over the redistricting, and we've already discussed that. But they have to move on, and they have to think about what's going to be in the best interest of the state going forward. I mean, Judge LaSalle certainly had nothing to do with the redistricting case,
Correct.
And I think I agree with what the comments that were made, that this is really more of not looking at whether he would be a good chief, but just to see if you can play to your progressive base without really looking at what the judge is going to do and his capabilities.
Let's assume that he makes it through the Judiciary Committee, which I can't, since they've now stacked the Judiciary Committee, I can't see how that would happen. But let's assume that he does, and my understanding is that there's still some in the corners where his support is, including on the second floor, which is in the governor's office. They still feel fairly confident that they're going to be able to get this across the line. One might suggest that perhaps there was an opportunity to cut a deal, and I'm sorry for folks who feel that that's inappropriate to have a conversation regarding the judiciary and deal making. But the reality is that there was an opportunity when the legislature was raising its own pay. Or raising the pay of the next seated legislature, which is effectively a lot like the last seated legislature, although not entirely. But there was an opportunity for the governor to, try and strike a deal, and she did not, for whatever reason.
I think you have to give her credit for
yes,
that.
You might say that it was. She might say inappropriate. I think that Hector LaSalle is such a strong candidate; he can stand on his own, and I don't need to make a deal. I don't know what her thinking was, but perhaps that's what it was. So the point is, let's say that he gets through the Judiciary Committee, and then he gets to the floor. And then he can't get made unless the Republicans make him. Now we're in a situation where he's now hamstrung entering into his chiefdom because the progressives will say, see, that proves our point. He needed Republicans to get him over the line.
Well, there's nothing, I don't think that's going to hamstring him. I don't think there's anything wrong with having a chief judge that's supported by both Democrats.
You don't, but they do. The progressives do.
I don't think as a general rule, there's anything wrong with having a chief judge that's supported by Republicans and Democrats. He's got substantial Democratic support as well. So to have a chief in the middle, especially, and we've talked about this a number of times, the court is divided. To have somebody that's chief, that's in the middle, that could possibly unify both sides is, I would think, a good thing.
Well, it's not working for Roberts.
Well, I'm not sure.
Okay. I don't know. Maybe it is.
If you were able to see this, you would have been really.
Well, it may not be working for Roberts, because that court is just hopelessly dreadful. He's one of the few decent judges on that court. But with regard to the Court of Appeals, let's just be clear about it. It has been a pretty bad court, a pretty weak court for the last several years. You're not going to find any serious observer of this court or of state courts around the country to say this is one of the great courts. No,
and
it's just not.
Isn't their caseload very low?
It's not a good court.
Hasn't the caseload also been low, Vin?
Low? It's ridiculously low.
Why do you egg him on like that?
Because I like
what he's
I just
been.
Think it's
his mantra.
It's true though. I mean, look, there was a time when the New York State High Court was a court that people looked to for for guidance and for groundbreaking decisions. I'm not certain that if anyone knows it exists anymore outside of New York, that people are looking to that, with the exception of the Happy the Elephant case, which was a very interesting case.
But wait a minute, Liz, you don't have to go that far into the past. When Lippman was the chief, I had chief justices from around the country telling me how influential the court was. They're all paying attention to the Court of Appeals again. It hasn't been that long in the past. When Wackler was the chief, at least in his early years, the same thing, very influential. When Kay was the chief early on, influential. When Cook was the chief, Fuld was the chief. You don't have to go that far in the past.
We're going to do another podcast with Vin Bonventre's top 10 rock star chief judges.
We had some really
Two people will listen to that.
Everyone they can't all be the best.
We've had some really superb chief judges who have ensured that the Court of Appeals was one of the best court in the country.
Just for curiosity's sake, what's pending before the court right now of significance that we think that the court has the capability of reestablishing itself in that matter? I mean, it also has to agree to hear cases, obviously, which ostensibly the new chief would, have a significant say in.
Well, the interesting about your question is that with regard to the Court of Appeals, it's not like the Supreme Court where you say, oh, there are these, 5 or 10 cases coming that, are just blockbuster cases. What happens at the Court of Appeals there are these cases which might seem to be routine. So there are these routine search and seizure cases or routine interrogation cases or routine workers' rights cases. And they become major precedents at the Court of Appeals, depending upon what the court does with them. So, for example, with regard to search and seizure cases, with regard to appeals of post-conviction relief cases, the Court of Appeals has just made a disaster out of the jurisprudence in New York over the last few years. And these are cases that most people wouldn't know about. But, those of us who are complete nerds and apparently have nothing better to do than read all the Court of Appeals decisions, we see these things and they become precedents. And if you have a great court, again, the court can start slicing and dicing and make some distance between itself and these prior cases.
What's the timeline? In other words, is there a time by which Hector LaSalle's nomination expires?
30 days, right? No, it doesn't expire.
It doesn't expire.
They have to vote on it within 30 days.
Unless he removes himself from consideration.
Oh, yeah, that's
I'm not
right.
considering that. I'm not saying he
I don't think
should,
there's any
but we
indication
have,
that that's
no,
happening.
there's not. But there have been, for example, appointments. I mean, that's what happened to Garland, if I remember correctly.
Yeah, but I don't know that that's happened with the Court of Appeals.
No, it's never happened with the Court of Appeals.
There's nothing in the law that says that the nomination expires. And in fact, as we know, if the Senate does not make its decision confirm or reject within 30 days, there's no penalty, and there's nothing to suggest that if they do it in 60 days, that's not valid. In fact, the law seems to suggest that even if the deadlines are missed, it's still valid. We saw that with Cuomo. Remember when Cuomo
right.
refused to reappoint Victoria Graffio?
Oh, right, yeah.
He missed the deadline. And the point was that there's no penalty, number one. And number two, what he did was still valid. That's what the law says.
Yeah, they said that they say there's a deadline in the law, but there's no penalty if it doesn't occur.
That's right.
I want to talk, if I could, about there's one more case that the group raised, and where they said that Judge LaSalle has, run
Corbin
roughshod. Yeah, Corbin roughshod over due process. This was a case where a criminal defendant agreed to a plea, and as part of the plea agreed to waive any right to appeal, then later decided after he pled that he wanted an appeal. And the second department, that decision that Judge LaSalle signed on to, affirmed the lower court.
The waiver,
affirmed the waiver. And this is being portrayed as somehow running roughshod over
due process.
I mean, it's a waiver of an appeal. Right? Do you have any thoughts? I'm sure you wrote about this too, Vin, right?
And, well, let me go further, because the professors went further and they said that this opinion of the appellate division, which LaSalle joined, was repudiated by the Court of Appeals. No, it was not. It absolutely was not. I don't know where
does this not concern you that these law professors?
Well, what happened was 5 years later, the Court of Appeals took a different case with a different set of facts and ruled differently.
Because the trial judge had mischaracterized the nature of the waiver of appeal.
In the second case.
What does all of this say about a whole separate issue regarding the I don't know what the right word is, the law professors themselves and the understanding that they may or may not have of the law, which is a little bit concerning.
Well, I think they know the law, right? I mean, they're just not, they're
They're choosing to
manipulating it.
manipulate it for political gain. I guess that's fine for law professors, but not for anybody else. Sure, okay.
Well, I would bet that most of the professors that sign probably don't know that much about the Court of Appeals or New York law, but they heard, and they heard by individuals they rely upon that Hector LaSalle is a terrible conservative and he's going to continue what the De Fiori court has been doing. And so they said, okay, we trust you and we sign on to it. I think that's what happened. I think that's exactly what happened. I see the names of some of these professors. If they read these cases, they would know exactly what David is talking about.
Don't they have a due diligence responsibility to do that before they start signing on willy-nilly to letters? I mean, look, we don't know that they did and we don't know that they didn't. We're not trying to cast aspersions necessarily, but I do agree. And I'm a layperson and I read these cases and I was like, okay, I don't see the fact pattern that is bearing out in terms of support of the case that these individuals are making.
So they probably didn't read them. They didn't read them. They were told by somebody they relied upon that these cases suggest this, that, and the other thing about LaSalle, which they just don't.
And the problem that we're seeing now is that this is being expressed to the senators that are voting on the nominee, and they haven't read the cases either, and they're taking as gospel this letter from the law professors without bothering to either read it or to try to investigate a little further as to what the judges actually,
or worse yet, they have investigated, or they don't care to investigate because it's not, again, getting back to, because I'm starting to sound like a broken record, but whatever.
I think you're absolutely right, Liz. I think you're right. They're pandering to the base.
It's about politics. It's not about whether or not Hector LaSalle would actually be a good chief judge, which, and again, look, this isn't a lifetime appointment, right? So I know a lot is at stake here, but it's not like the U.S. Supreme Court, in fact, where Hector LaSalle gets on the court and then subsequently goes rogue and decides to be whatever it is that, which we have seen at the U.S. Supreme Court on numerous occasions. Once you say a lot of things in your confirmation process, or you try to say as little as possible, and then you get on the court and you expose yourself for whoever you are, and then you grow and change and you're lobbied by your colleagues, and et cetera, and so forth. So that's not the case with the High Court in New York. There is actually a date certain by which you expire, not physically. You might well expire, but you can't stay on past. So the point is, like, we actually don't have any indication that he would be the boogeyman that these individuals insist that he would be, other than for political gain.
Well, we have good indication that he is not the boogeyman they're suggesting. But also, to be fair, his record does not suggest that he's the kind of liberal, progressive judge, at least so far, that, many of the liberal politicians and liberal professors would hope to have been appointed to the Court of Appeals. I mean, come on. And look, let's not mince any words. If the commission was not so disgraceful in excluding some of the sitting members of the Court of Appeals, right, like Jenny Rivera and Rowan Wilson and Shirley Troutman, we probably wouldn't be in this position, because I would imagine that Hochul would have nominated either Wilson or Troutman.
Yeah, but look, we've got a commission that is a political entity, right? It was set up.
Oh, you think it's political?
Well, it certainly is, because by its very bylaws, it has to be bipartisan, right? It's got 6 Democrats, 6 Republicans. So are you surprised that it's not a full-fledged, ultra liberal selection? No, it's a moderate selection, because that's the way it was set up. There's nothing nefarious about it. It was set up to be. It was set up that way.
Fine. So the point is, if you have a problem with the outcome of the process, then quote unquote fix, address, change, revisit the process. But to castigate the outcome of a process that is designed, as David just noted, to be a middle of the road pragmatic experience, then, that's what you end up with. If you have a desire to make the process and manipulate the process or change the process such that it becomes an outcome, or it gets an outcome that you're more happy with as a progressive, then do that. But to say, well, this particular process after the fact resulted in something that we don't like is kind of crying over spilled milk.
Well, no, I'm not at all talking about the fact that the commission came out with a list that, and I wanted only really liberal candidates, on that list. We're not talking about that, but we're talking about how could you exclude certain of these people who apparently did apply to the court. And look, we know darn well that in the past, this commission has put people on the list that certainly do not belong on the list. They just did not belong on as a matter of merit, as a matter of pure merit. And to say that these lists that have been produced by the commission are based on pure merit is just laughable. It's just laughable. Are there usually people who are terrific that are on this list, whether they're liberal or conservative? Yes. Are there usually a few real clunkers on the list? Yeah, that's also true.
To be clear, Vin Bonventre using the word clunker is not something that we sanction or necessarily support. I just want to put that out.
Clunker is only Vin. I'll say this. The Bar Association looked at the entire list, found all 7 of the individuals on the list to be qualified, and 3, including Judge LaSalle, to be well qualified.
Yes.
It's highest rating, right?
Yes.
So there was no real clunkers. I mean, some might be, you could view as potentially more experienced or more visionary, but there was no clunkers on the list.
No, I think this was a pretty strong list. I think it would have been even stronger if you had some other people on the list who I am sure were deliberately excluded by some of the commissioners the way they were voted.
Just to be clear, also the speculation in advance of the list coming out, or even I think even of the making of the list, was that Rowan Wilson would be a great choice because Rowan Wilson would give the governor 2 bites at the apple if in fact she'd
Troutman. You're right.
Or
Troutman. Yeah.
Right. So the idea that maybe some people in some corners thought that she shouldn't get 2 bites at the apple, I don't know. But again, like the idea, just to level set, that the idea that somehow the judiciary, and we have had this conversation, and I think we will probably have it every single time we get together, the idea that the judiciary is somehow above politics or not political or whatever, is just horse feathers.
Horse feathers again.
Feathers. I said clunker. That was cleaner than horse feathers.
Horse feathers is not dirty.
Family show.
I wanted to say something else entirely. I did not, because David was giving me the stink eye.
Well, Liz talks, I write.
Oh, boy,
and sometimes I write. But
I hope you're writing down what she's saying. Right, because it's all good.
Well,
it's all good.
Liz is brilliant. She knows I love her. But look, I've actually been looking at cases now which the professors did not mention, and these progressive groups did not mention, and actually their opinions written by LaSalle that are pretty darn liberal.
Ooh, are you gonna wait? Did you write about that?
Coming out.
I'm writing about that right now.
Oh, that's a good one.
What's the difference? You don't read what I write anyway.
I skim.
Now she's interested. You can see it, NewYorkCourtWatcher.com. NewYorkCourtWatcher.com. It'll be out.
Free plug.
I was working on it.
It'll probably be out before our podcast is released. So go to NewYorkCourtWatcher.com. You can find out all you need to know about presiding Judge LaSalle's past decisions. In the opinion of our wonderful guest, Professor Vin Bonventre. I want to thank you, Vin. I want to thank you, Liz. This has been a great discussion, to be continued. We will see what happens, and we'll talk soon. Thank you both.
Thank you.
Thank you both.
This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.